English Colonial Law on Slavery, spelling and a bit of wording modernized by James Couture. Original source, William Waller Henning. December 14, 1662, Charles II, 2170, Act 12. Negro women's children to serve according to the condition of the mother. Whereas some doubts have arisen whether children got by any Englishman upon a Negro woman should be slave or free, be it therefore enacted and declared by this present Grand Assembly that all children born in this country shall be held slaves or free only according to the condition of the mother. And if any Christian shall commit fornication with a Negro man or woman, he or she so offending shall pay double the fines imposed by the former act. September 19, 1667, Charles II, Act 3, 2260, an act declaring that baptism of slaves does not exempt them from slavery. Whereas some doubts have risen whether children that are slaves by birth and by the charity and piety of their owners partake of the blessed sacrament of baptism, should by virtue of their baptism be made free, it is enacted and declared by this Grand Assembly and the authority thereof that the conferring of baptism does not alter the condition of the person as to his bondage or freedom, that many masters, freed from this doubt, may more carefully seek the propagation of Christianity by permitting children, though slaves, or older slaves if capable, to be admitted to that sacrament. October 21st, 1669, Charles II, 2270, Act 1. An act about the casual killing of slaves. Whereas the only law in force for the punishment of disobedient servants resisting their master, mistress, or overseer cannot be inflicted upon Negroes, nor the stubbornness of many of them by other than violent means put down, be it enacted and declared by this Grand Assembly, if any slave resist his master, or others by his master's order correcting him, and by the extremity of the correction should chance to die, that his death shall not be counted as a felony, but the master, or that other person appointed by the master to punish him, be free from being bothered, since it cannot be assumed that premeditated malice, which alone makes murder felony, should induce any man to destroy his own property. October 4th, 1705, and Chapter 23, 3333. An act declaring Negro, mulatto, and Indian slaves within this dominion to be real estate. 1. For the better settling and preservation of property and inherited estates within this land, be it enacted by the governor, council, and burgesses, representatives, of this present General Assembly, and it is hereby enacted by the authority of the same, that from and after the passing of this act, all Negro, mulatto, and Indian slaves, in all courts and other places within this land, shall be held, taken, and judged to be real estate, land and not just generic property, and shall descend onto the heirs and widows of persons departing this life according to the manner and custom of land of inheritance. Tricky legal section cut, James Couture. 4. Provided also that all such slaves shall be considered collateral for the payment of debts, and may be taken like other property may be. Multiple sections cut. 10. Provided, and be it enacted, that when any person dies without a will, leaving several children, in that case all the slaves of such person, except the widow's dower, which is to be first set apart, shall be inventoried and appraised, and the value thereof shall be equally divided amongst the children, and the several proportions, according to such valuation and appraising, shall be paid by the heir, to whom the said slaves shall descend by virtue of this act, to all the other children. And thereupon it shall and may be lawful for the other children and their agents or administrators, as the case shall be, to sue, using the common law, against the primary heir for the recovery of their respective proportions.